Korean competition law cases. According to Article 1 of the Korean competition law, the purpose is to prevent business undertakings from abusing their market-dominant position and concentrating excessive economic power, regulate cartels and unfair trade practices, and promote fair and free trade to coordinate creative business activities, protect consumers, and promote balanced development of the national economy. In this video, provisions and legal cases of the Korean competition law will be discussed. Check out more videos about the definition and meaning of the Korean competition law at KLRI channel. Article 3-2(1) of the Korean Competition Act prohibits abuse of market-dominant position. The types of abuse prohibited by Korean competition law include refusal to deal or supply, imposition of disadvantageous conditions, discriminatory treatment, predatory pricing, exclusive dealing, and significant harm to consumer interests. One of the examples is the Microsoft case in 2006. The following three tying of Microsoft were problematic in this case. 1. Tie Windows Media Player, WMS, to Windows Server Operating System. 2. Tie Windows Media Player, WMP, to Windows PC Operating System. 3. Tie Messenger to Windows PC Operating System. The Korea Fair Trade Commission, or KFTC, judged that Microsoft's three tied sales are unfair bundling, each of which constitutes obstruction of business activities, harming of consumer interests, and tying among unfair trade practices. As a corrective action, KFTC let WMS be sold separately from Windows Server Operating System, and with regard to PC Operating System, it was ordered to supply a separate version of WMP and Messenger from Windows XP in principle. Competition is very tiring for the businesses. The easiest action or strategy to avoid competition is cartel, or also known as the illegal cartel conduct. Undertakings will attempt various joint activities, such as fixing prices and dividing market. Each country's competition laws are designed to deal strongly with cartels. In the Graphite Electrode case in 2006, U.S. company A, Germany company B, and Japanese companies C, D, E, and F agreed on the sale price and market division of graphite electrode to all markets, including Korea, from May 1992 to February 1998, and as a result, the price of graphite electrode jumped more than 50%. The KFTC ordered corrective measure and imposed fine on the 6 foreign companies participating in the international cartel of the graphite electrode. It is the first case to impose sanctions on foreign operators based in foreign countries by applying the Korean Competition Act. A conglomerate refers to the undertaking's combination that dissolves the economic independence of an individual entity by integrating their activities under a single controlling system through capital, human, and organizational connections between the entities. The competition law prohibits, in principle, a combination of entities that substantially restrict competition in a relevant market. There is a beer Soju case in 2006. Beer Company A, with a market share of 57.9%, reported its combination to KFTC after acquiring 52.1% of shares of a Soju company, which had a market share of 82.4%, and Company A became the largest shareholder. KFTC first considered whether the combination is horizontal or conglomerate, and as a result, approved the combination of Company A and C under condition. Innovative growth can be well achieved through fair trade practices. KFTC's expertise has reached a significant level through active enforcement of competition law over the past 40 years. The court's rulings also have accumulated considerable amounts and have been forming independent laws that distinguish them from the United States and the European Union, and have contributed significantly to improving anti-competitive behavior and establishing a fair trade order. More videos are available at KLRI channel. Please inquire to pr@klri.re.kr.